It's great to be here tonight and great to be a part of this series and this event. I'd like to first start by thanking Leah George Wilson for welcoming me back home and for her prayer and her kind thoughts about the event tonight and the feelings that we need to have in the room. I'd like to also thank Renee for her kind introduction, and thank Lawyers' Rights Watch, Amnesty International, Vancouver Public Library, and the Hul'qumi'num Treaty Group for inviting me to be a part of this series. I'm very humbled and honored to be part of this event that's been going on for the past few months. As Renee said, I'm Coast Salish and a member of Cowichan tribes, and my traditional name is Satafia. And part of the lessons that I learned from my elders while I was conducting this work or learning about Coast Salish traditions, legal traditions, is that it's always important to share with my audience my traditional name, because it anchors me within the work that I do, or tells people in the room where I come from and what my family history is. So as part of our laws, it's important to start with that introduction. So, my talk tonight is titled Cooperation or Conquest, but really it's about Coast Salish legal traditions and how we can work to have some form of recognition of this Indigenous legal tradition within the Canadian state. So Aboriginal peoples were the earliest practitioners of law in Canada. Living in communities and nations across the land, they developed norms and practices to govern their social interaction, regulate trade, resolve disputes, and govern the relationships between different nations. The diverse traditions of Aboriginal peoples developed into highly developed systems of law that guided Aboriginal societies for centuries in the governance of community, the environment, and relationships between people. Passed down through generations in stories, songs, ceremonies, and practices. These legal traditions reflect the unique experiences of different Aboriginal peoples and communities, embodying their values and beliefs and resonating within their cultures. The first Europeans to arrive in North America recognized Indigenous legal traditions and often respected and followed Indigenous laws. Aboriginal laws, protocols, and procedures provided the framework for the first treaties between Aboriginal peoples and the Dutch, French, and British crowns. Most often, commercial transactions were conducted in accordance with Indigenous traditions, with the giving of gifts, and the standards of trade often based on Indigenous legal concepts. In the personal realm, many early marriages between Indigenous women and European men were solemnized according to Indigenous legal traditions. However, the influence of Aboriginal laws waned in the face of increasing European settlement. Early cooperation was replaced by policies of assimilation, and by the 1800s, Indigenous legal traditions often were ignored, and many customary practices and ceremonies were banned. Aboriginal children were removed from their homes and forced to attend residential schools, where the use of their Indigenous languages were prohibited. The impact on Aboriginal laws, cultures, and communities has been devastating. In the place of laws and dispute resolution mechanisms that developed in particular cultural contexts and resonated with the values and beliefs of the people governed by them, a legal system reflecting the values and culture of the European settlers was imposed on Aboriginal peoples. Many Aboriginal communities today struggle with extreme poverty, their culture, identity, and their communities fractured as a result of decades of assimilationist policies. However, Indigenous legal traditions have not disappeared. Many Aboriginal communities have maintained and developed their laws and continue to be guided by them in governance and dispute resolution. Other communities have begun the difficult task of reclaiming and revitalizing their traditions and the values upon which they are based. Events like tonight demonstrate that there is a growing recognition of the importance of Indigenous laws and legal traditions to the culture, economic, and social health of Aboriginal peoples, both within Aboriginal communities and non-Aboriginal communities. Many identify the reinvigoration of Indigenous legal traditions as vital to the autonomy of Aboriginal peoples. But while Canada is a legally pluralistic state in which the common law and civil law are recognized and operate alongside each other, Indigenous laws are not always valued or given room to operate, develop, and flourish. Ensuring that Aboriginal peoples have the political space and resources to cultivate and refine Indigenous laws in accordance with their traditions could contribute not only to the health of Aboriginal communities, but also to the reconciliation between the Canadian state and Aboriginal peoples. The overarching purpose of this research is to bring about a greater recognition and reconciliation of Coast Salish legal traditions with the Western legal system. As an Indigenous scholar of Coast Salish descent residing in Canada, the question of what is law is not something that I can answer simply by visiting a law school library. Neither is it something that I can answer simply by immersing myself in our culture, traditions, and customs and practices. As I have discovered, law is not only a matter of ideas, but rather a process or an activity. But how does one describe this process? How does one reconcile the differences that may exist between the laws found in a law school library and the laws practiced in the traditional longhouse of my people? What law prevails when a provincial statute allows for the desecration of an ancient Hul'qumi'num burial ground and a Hul'qumi'num law of non-avoidance prohibits it? The first part of my presentation will aim to broaden our understanding by examining the inherent legal principles of the Coast Salish legal tradition, or Snowaya. I hope to reinforce the notion that Canadian society is not merely a conglomerate of individuals who fall under the same laws. In this sense, I aim to educate both Indigenous and non-Indigenous societies about the pluralistic nature of law. The second part of this presentation relates to developing a process by which to reconcile these different and sometimes competing legal traditions. This process of reconciliation is not simply a struggle of Indigenous peoples to be free from the influence of the Western legal system, but rather a process of asserting the power we possess as communities and individuals to make legal decisions that affect our lives. As political theorist James Tully has stated, Indigenous peoples resist colonization in two ways. First, they struggle against the structure of domination as a whole and for the sake of their freedom as peoples. Second, they struggle within the structure of domination vis-a-vis techniques of government by exercising their freedom of thought and action with the aim of modifying the system in the short term and transforming it from within the long term. Accordingly, a discussion on recognition of Indigenous legal traditions cannot be characterized by the boundaries of the Canadian pluralist political system. Kevin Brunel describes the supplementary strategy as the third space of sovereignty, and states, the Indigenous political effort to construct and maintain the coherence of community is premised on straddling and thus remarking the boundaries that purport to secure the coherence of American community. This does not mean that Indigenous political actors can deny the real power and equity between their communities and the American nation. Rather, the lesson here is that in generating political claims, Indigenous peoples do not simply adhere to the options set out by the American political framework, By refusing the imperial binary through a politics on the boundaries, Indigenous peoples give their political identity, agency, and autonomy fuller expression, one that is less constrained by colonial impositions. For the purposes of my work, I tend to understand this space by which Indigenous groups can operate both within and outside the Canadian legal system at the same time as a space of shared sovereignty. So what is law? As an Indigenous scholar of Coast Salish descent, the question of what is law is a question I have grappled with for many years. Through my research, I have come to see that law is not only a matter of ideas, but as I said, law is also a practice or an activity. While law certainly draws from and mingles with ideas, both local and global, at the end of the day, law must be applied in a particular context. Law comes to life in people's lives, not just their minds. As such, to be persuasive, law cannot be separated from the societies from which it arises. It must make sense in its place, and it cannot be separated from its surrounding culture. In thinking about this grounded nature of law, I've gained further insight about law's character from discussions with Professor John Burroughs. In his book, Canada's Indigenous Constitution, Professor Burroughs suggests that law cannot be understood apart from culture. He writes, "Law is a culture of argument that provides a place and a set of institutions and methods where this conversation process can go on, as well as a second conversation by which the first is criticized and judged. Canada's other legal traditions are also embedded in a culture of argument. Each contains a degree of ambiguity that requires judgment beyond its initial formulation. This is why every legal system employs different methods of interpretation to help bridge ambiguities." The thesis of Professor Burroughs' book is that Indigenous law can be explained by reference to the cultures in which Indigenous peoples live. Since in the contemporary context, Indigenous peoples live in a cross-cultural context, the laws that guide their lives must be drawn from the cultures that surround them. I have been shaped by at least two legal cultures growing up in my traditional territory, the common law and Coast Salish law. Since I live in this bi-juridical space, I have not only obligations to follow the laws of Canada, but also to my people and my ancestors to follow our Snowayat. Snowayat is a Hul'qumi'num word that my elders have described to me as meaning our way of life, our way of being on Mother Earth. It is our language, our governance, our culture and tradition, our sacred bathing holes. It is spirituality and all the teachings. Our Snowayat helps regulate our relationships and resolve our disputes. It contains standards and practices for judgment and decision-making. It is intimately connected to our culture. In fact, I would go so far as to argue that it encompasses the basic normative principles upon which our culture is based. All of our practices and institutions stem from the guiding principles of our Snowayat. Since our culture is still alive, as carried on by our elders and others, our Snowayat did not disappear when the first settlers arrived in our traditional territories. Rather, these teachings and traditions have carried on to the present day through stories, practices, and customs. However, I recognize that some not familiar with or subject to this system may not regard our Snowayat as law. However, I would argue that it is possible to discern legal principles within such teachings, and that these teachings do more than merely reinforce societal norms. These general descriptions of Snowayat support the hypothesis of John Burroughs that law cannot be separated from culture. As my elders have expressed to me, Snowayat is a way of life, not merely a codification of accepted practices and sanctions. It touches on all aspects of life and cannot be separated from our relations to each other, to the natural world, or to the spiritual world. However, recognizing the intricacies and complexities of this legal tradition, how can it be applied in today's modern context? There are 7 key principles that have been identified to me as forming part of our Snowiath. These concepts are kinship, respect, trust, sharing, love, forgiveness, and responsibility. These are key Hul'qumi'num legal concepts which are applied as guiding norms and values with deep roots in Hul'qumi'num custom and tradition in virtually every important area of life in the community. As such, I understand them to be inherent legal principles. Although these principles are certainly drawn upon in the practice of Coast Salish law and traditions, action does not necessitate their existence, nor their recognition within the legal tradition. In essence, these 7 key legal concepts represent a set of legal principles that seek to foster harmony, peacefulness, solidarity, and kinship between all living beings and nature in the world. However, these key 7 concepts or doctrines are not basic legal principles in the sense that they can be applied directly to a legal question. Rather, when we speak about these 7 key concepts in a legal context, they describe conditions generated through law. As such, they are somewhat similar to the Western concept of natural law. They describe an objective moral reality constructed from a set of authoritative legal principles. In a sense, Snowiath is a state or condition, and the Hul'qumi'num legal tradition, encompassing all the animating norms, customs, and traditions, those are the things that produce or maintain that state. As a result, Hul'qumi'num law functions as the device or tool that produces or maintains the state of Snowiath. The 7 values articulated to me by my elders provides the Hul'qumi'num people with a framework of thinking, planning, and decision-making so that right choices lead to living a good life. This notion of a legal tradition built on inherent legal principles is not exclusive to the Hul'qumi'num people, in particular, or in judicial decision-making. In describing the nature of law, in particular constitutional law, Frank R. Scott stated, "Every legal change involves a choice of values, a selection of objectives. Changing a constitution confronts a society with the most important choices, for in the Constitution will be found the philosophical principles and rules which largely determine the relation of the individual and of the cultural groups to one another and to the state." Perhaps the major difference between Western and Indigenous legal traditions is that Indigenous people embrace the fluidity of their legal traditions. Because Snowiath applies to all aspects of Hul'qumi'num culture, these concepts are capable of describing other conditions when spoke of in different contexts. They are integral to the Hul'qumi'num creation story. They are also integral to Hul'qumi'num spiritual life. In summary, they underlie, along with corresponding virtues, all of the Hul'qumi'num culture, including customs, traditions, philosophy, language, spirituality, sense of place, and identity. So let's consider the application of these inherent legal principles to an environmental law situation. In 2004, Penelakut elders and Salt Spring Island residents asked the Environmental Appeal Board to issue an order to stop development at Walker Hook on Salt Spring Island. Sablefin Hatcheries Limited wanted to use the area for effluent from its black cod fish hatchery on Salt Spring Island. After the Minister of Water, Land and Air Protection issued a permit, Sablefin agreed to do some digging to determine if there were any ancestral remains or artifacts on Walker's Hook. 13 bodies were found. However, further exploration revealed that there were the remains of at least 700 and possibly as many as 1,500 ancestors of the Penelakut, Cowichan, Chemainus, Halal, and Layaxan First Nations on this site. The desecration at Walker's Hook was brought before the Environmental Appeal Board of British Columbia by a group of Penelakut First Nations elders. Myris James, on behalf of the Penelakut elders, applied for a stay of the Waste Management Act approval pursuant to Section 11, subsection 1, which provides that a manager may approve the introduction of waste into the environment for a period of up to 15 months without issuing a permit. So the approval allowed Sablefin to discharge effluent from its fish hatchery into the injection wells located on Walker's Hook for a 15-month period. In the appeal, the Penelakut elders argued that the discharge of effluent permitted under the approval would permanently destroy the historic, aesthetic, and spiritual qualities of Walker's Hook and would prevent Hul'qumi'num people from using the site for spiritual practices, thereby depriving them of their Aboriginal rights. They argued that the discharge of effluent, which contained dissolved nutrients and other substances, to a sacred site, such as Walker Hook, was an affront to their culture and history, and that there was no way to clean the effluent from the grave sites and restore the spiritual sacredness of the site once it had been desecrated. As stated by August Sylvester, the use of the ancestral burial ground as a sewage treatment site is very hurtful to our people. It is counter to all of our beliefs. There are rules to follow at grave sites. For example, you are not allowed to even spit on the ground. On that ground, you do not drag your feet or kick rocks. If you had to dig in that ground, you have to first put on a handkerchief, red ochre, and pray. This is pursuant to our laws on how to treat all graveyards. This law of non-disturbance is based upon the principles of respect and reciprocity. This means that ancient sites and remains should not be physically disturbed under inappropriate circumstances. According to the Hul'qumi'num elders, these sites are valued as powerful ancestral places that must be protected out of respect for past generations. In fact, the disturbance of these ancestral places is believed to have negative consequences for the living. However, there are instances when Hul'qumi'num people will intentionally disturb and even remove the remains of the dead. For example, there are current Hul'qumi'num practices that allow for the disturbance of human remains if they are unalterably threatened. Sylvia Harris provides one such example, and she stated, "Traditionally, if remains were disturbed, we would have to take care of them like it was a burial. When my mom was alive, when George and I were first married, the shore on the Seattle Yacht Club was washing away and it exposed a burial site. They found human remains, and so my mom and George cemented the area so that it wouldn't be further disturbed. A good portion of the time, people try and keep a burial site the way it is. If the site is going to be disturbed or used, then we have to take care of those remains. If you don't take care of it, something could happen to those ancestors' families or young ones. That's our teachings, that's our way. Other people don't think about it that way." However, it is important to note that the practices that allow for the intentional disturbances of human remains from their original burial location are not intended to be disrespectful to the dead. Therefore, one can see that the solutions posed by some private landowners to simply reinter those remains so that development can continue is completely contrary to the laws of the Hul'qumi'num people. In finding against the Penelakut, the EAB stated that the applicant provided insufficient evidence to counter the conclusions that all potential contaminants will be at safe levels upon entering the receiving environment. The discharge water quality will be acceptable for any marine life, and discharge will not occur within the local clam beds or deeper waters. The panel found that the applicant did not adduce sufficient evidence to establish that the discharge of effluent in accordance with the approval would cause irreparable harm to cultural deposits at the site if the stay was denied. These two differing opinions on the treatment and values of these sacred sites illustrate that conflicts can occur within a state which contains more than one legal tradition. As expressed by August Sylvester, the Canadian laws that permitted the approval are in direct confrontation with the laws of the Hul'qumi'num people.